I represent Mr. David Lopez.
And are you Mr. Lopez?
Yes, ma'am.
All right, so we're here because the state has filed a motion for a no contact order as a condition of bond. They're stating that the judge who entered the bond did not place any conditions on you as a condition of bond. The state is asking for no contact with the complainant. Is that the only request?
At this time, yes.
All right, so, and off the record defense, you said that you were opposed to that.
I am, Your Honor.
All right, are there any witnesses?
No, Your Honor.
All right, the court will hear argument. So they,
Possibly, if need be, witnesses. Sorry, from the defense.
all right,
Need be.
it may need be.
All
All right. So do you have any witnesses to call today or no?
The state does not.
Okay, then I'll call Sue Lynn King.
Okay.
We're here, sir. You're back against the couch.
Right. Can you raise your right hand?
Fine.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. If you'll state your name for the record and spell your last name.
Sue Lynn King, AING.
All right, you may proceed.
Ms. King, I was appointed to represent David Lopez, and you understand what he is charged with. Is that correct?
Okay.
He's charged with aggravated sexual assault of a child, and you've seen the indictment. He's also charged as a repeater. Is that correct?
Yes,
And have we talked about that repeater allegation?
yes,
Have you seen the judgment of the repeater allegation?
yes, I have.
And is the picture in the judgment of David Lopez?
No,
Is the date of birth of David Lopez?
no,
Is the height of David Lopez?
no,
Is where he served and he was ultimately found guilty in Harris County? In your knowledge, has David Lopez, your David Lopez, ever been to Houston?
he's been in Houston.
Right out of the gate, notice what's happening here. The court isn't debating guilt yet. It's dissecting jurisdiction, background, and credibility. Questions about Houston, prison history, and bond conditions aren't random. They're laying the foundation for whether this defendant even fits a narrative the state is pushing. And when you hear aggravated sexual assault of a child with a repeater allegation, understand this. That label alone can completely reshape bond conditions, public perception, and the judge's risk analysis. This is where the stakes quietly skyrocket.
Custody of your granddaughter, why?
They were in foster care due to
Let me stop. They, who's they?
all three girls.
Okay, so there is Phoenix, and she's the oldest.
Uh-huh.
There's Annabelle.
In 2016 and brought them to Texas from Tennessee due to their grandmother and her brother molesting them. They were taken into state custody. Phoenix came out with a lot of issues psychologically. He was in counseling from the beginning and is still in counseling.
You have dealt with CPS on multiple occasions, correct?
Yes, they were always in my home at the time the girls were brought in.
But you have complied with all of CPS's requirements, safety plans, and anything. You've always been available to speak with them, correct?
Always.
Okay, and it was CPS that allowed David to come back to the house, correct?
Yes, it was.
Now, at any time or on multiple occasions, did Phoenix recant her story?
Multiple times to me, and then she had she went back to child save and recanted all of it.
Just one second. Let's pause for a moment. Because I have an idea that she's going to say that she wants him there. She doesn't want the no contact order. So does anybody have any way to have the CPS worker zoom in?
The state can speak to that. We do have CPS records. I have reviewed them in full. CPS, I guess their concerns were illegal because cameras were put up in the homes.
Well, no, I mean, does anybody have a CPS worker to zoom in for me to listen what the CPS worker has to say?
No, I just
Is
have a
that possible?
CPS report.
All right. And then with regards to the indictment, sorry to interrupt your cross, but these are questions as I'm hearing their testimony that I would like answered. With regards to the indictment, Is the indictment correct?
No, Your Honor, there is an incorrect birth date on the repeat offender enhancement, so the state would be filing a motion to amend the indictment to.
And have you all had a chance to speak to the complainant?
We have, Your Honor, and this in raw record.
This is one of those moments that makes judges pause. Recantations, especially involving children, are legally complicated and emotionally loaded. Add CPS into the mix, and now you're dealing with overlapping authorities that don't always agree. The court is essentially asking, who do I trust more, the paperwork or the people who were physically inside that home? And when CPS allows the accused back into the house, that decision echoes loudly in a bond hearing like this.
How severe this is. CPS let him back in. They put up multiple cameras
17 inside the home.
around the house. And David also watches the other two kids, which both have autism. And every time he's out of the house, the kids revert back. This allegation came out in 2022. The investigator said that she recanted back then, but I'm going to go ahead and turn it over to the DA for review. And they didn't file until 2025. So I'm hearing all these stories, and I've met Phoenix, and it is a complex case. She has multiple personalities. She talks to multiple individuals. I've had ad-length conversations with her. She's the sweetest thing that has been tormented, but it is so wrong to be wrongfully accused on an allegation of this severity.
All right, so this is what I can tell parties I want. If somebody will pick up the phone, call the CPS worker. And was there a child's ad litem involved in this or no?
Not that I saw, Your Honor, throughout the CPS records.
Any attorneys? It's an attorney for the children.
They offered one,
Mhm.
It never went through for some reason.
All right, so someone can have, because here's my thing. I will listen to your testimony and I always keep an open mind, but it appears that she's going to say she doesn't want the no contact order. Am I right?
Yes, sir.
So I would like to hear from the caseworker. They're supposed to be objective. And I want to hear from them rather than just reading words on a page, because sometimes I have questions. So do y'all want to see if you all can call the caseworker? I'm sure they would zoom in.
State.
And then if you want to continue with your questioning of her, I'll listen.
I believe the judge kind of cut to the chase.
Yes,
You want David at home.
yes,
Do you need David at home?
we do need David at home.
Do
I'm a full-time nurse. I work sometimes up to 16 hours a day, 6 days a week. And his parents are also in the home, the grandma, they're also in the home, but they're 83 and 85. And they cannot physically handle the two youngest girls because sometimes whenever their mentation strikes, it gets completely out of control. David handles them, sits them down in the living room, turns on a movie in the living room, kind of keeps them all pretty much stable. Phoenix comes down, she sits in the living room on the couch on the end and watches TV with them. It's a family interaction. I can see everything they do in the house.
Let me ask you this. Has David ever alone with Phoenix?
Never alone with Phoenix.
Are there cameras that there are boundaries in the house?
There are boundaries in the house. If David is downstairs by himself, Phoenix does not come down because of the...
Watch how the judge subtly takes control here. This isn't about choosing sides, it's about neutrality. Judges rely on CPS workers because they're supposed to be objective, not emotionally invested. When the judge says, I want to hear from them rather than just reading words on a page, that's a signal. Testimony matters more than reports. This is the court slowing things down before making a decision that could permanently alter a family dynamic or expose a child to risk.
Backyard working on a playground for the younger two, and she accused David of something that he didn't do because she'd never been outside and David was only outside, and she accused him at the time he was working on the playground himself. Joseph was on the back porch watching, and she blatantly made an accusation against David that didn't happen.
In your opinion, do you think the children are safer with David in the house than David being out of the house?
Yes, I do. I think that they have developed such a relationship that taking David out of the house The youngest one actually reverted back to peeing on herself and peeing in the bed and unable to focus at school.
And how old is she?
She's 9, pigmentation about 3 to 5-year-old child.
All right.
Other questions?
Any questions, State?
Yes. So when David was arrested for this back in 2024, is that when that
Yes.
out of county?
Yes.
And since that time, actually, since 2023, he's been in the home with you in Phoenix.
Yes.
Even after these allegations came out.
Yes, because the courts cleared him. Or not the courts, but CPS cleared him. Right.
All right. So I have a couple of questions. Are there any objections?
Not from the state.
None from defense, Your Honor.
All right. So you say there are cameras in the house. Where are the cameras?
There are 3 just down the hallway for the girls.
Mhm.
There's one in the corner above the bathroom that looks at the youngest children's door
Mhm.
because Mia sometimes has the tendency to come out of her bedroom and fall downstairs.
Okay.
So there's a camera there and it triggers whenever somebody exits their bedroom. There is a camera in the corner of the hallway looking exactly this way down the hallway where the gate is, down the hallway here where the girls' room is, and on Phoenix's door with the back.
So correct me if I'm wrong.
Uh-huh.
So the only places there are no cameras are inside the bathrooms,
There are no cameras in the bathrooms.
but do cameras show anyone who's going into the bathroom?
Yes. And there are SD chips in each camera so we can record and document anything that may come out as an accusation. There is also, because Phoenix was suicidal at one point, she doesn't have a door on her bedroom because we had to watch her closely. For 2 weeks, she was on suicide watch before she went into the institution.
Mhm.
So there's a camera directly on that bed alone. She has privacy everywhere else.
So how many children in the household that are underage? And those are the 3 children that you took into your home?
Yes.
All right. And how many adults are in the household?
Uh,
All right. And who are the 5 adults?
my son, he's 30 years old. He is upstairs with the girls when they come out of the gate. His bedroom's right there.
Okay.
My father-in-law sleeps on the other end where the children's playroom and TV room is.
Okay.
And David's mother, who is downstairs at the very front of the house.
Okay.
And then me and David.
All right. Any other questions?
Yes, Ms. King, the 2 younger children, they're nonverbal, is that correct?
Oh, no, they're not normal. They're very verbal. They're very high functioning.
I functioning.
Yes.
No further questions.
Yes.
Just for clarification, Phoenix did go into inpatient care for how long?
She was in for 7 months this last time at Cedar Crest Hospital.
Okay, and so if she gave any indication whether this did or didn't happen to them as
Yes.
well, you weren't around.
I
They
wasn't
could talk
there.
there. And lastly, the state says that David was arrested on in 2024. It was actually March 19th of 2025. Is that correct?
That's right.
That's all, just for
All right.
That was the other place.
And other than this child, have any of the other children accused him?
accused him. No, Your Honor.
They
But
accused her
they are verbal and they accused Phoenix
while
of
she
acting
was
out.
institutionalized.
Okay.
And she knows that she did it. She will tell you.
Okay. All right. So if y'all can have this, the caseworker zoom in, the court will make its ruling.
Thank you, Your Honor, very much for your consideration.
Sure. You're welcome. And if you talk to Norma, once you have the number, she'll give you the Zoom link. I mean, there are no further witnesses.
That's correct, Your Honor.
All right. And Cindy, for the record, the state has informed the court that the caseworker on the CPS case and the supervisor are no longer employed with CPS. All right, I'll hear argument.
Yes, Your Honor. So the reason the state is asking for the no contact order, one, because of cases like this, these are bond conditions that are typically put in place. That was not put in place. The defendant was arrested out of county and then bonded out. So whoever magistrated in out of county did not put any conditions on. my understanding is that from reviewing the CPS records, yes, CPS did allow the defendant back in the home after these allegations came out, and also after they found reason to believe. And to me, that just does not seem reasonable. And so that is why the state is asking for the no contact order, because the child has been in the home with the defendant and with her mom.
This is a rare but fascinating compromise. No contact order, but instead the court orders ongoing surveillance transparency. That's not a slap on the wrist. That's the judge saying, I'm not convinced enough to separate the household, but I'm not blind either. Allowing the DA access to SD cards turns everyday home life into potential evidence. Every day becomes documented. For the defense, it's a gamble. For the prosecution, it's a monitoring lifeline.
Alleged complainant recanted. This case wasn't picked up until March 2025, where CPS had already allowed my client back in the home, and there has been no indication of anything going on since 2023. It has been status quo. He also bonded out on a $100,000 bond from the state's investigation, or from their investigator, which kind of charged him incorrectly. I believe his bond is overly intrusive. I would hate for his bond to be reduced and him to have to rebond out to go through the process, because he's already spent everything he had on the $100,000 bond. They have adequate cameras put in place. Everything has been status quo since. You've heard a very small portion of why the children need supervision at home, also David's supervision at home. He has cameras in all the right places that need be. There are other individuals in the house as well, and I just think it would be overburdensome for my client to have additional conditions that weren't put on until August of 2025, when the state is finally getting ready for this case. We've been ready, well, since March. I'm asking that the bonds remain in effect the way they are until trial, and we'll be ready.
All right. So this is what the court will note for the record. The indictment, and both parties have agreed that the indictment is incorrect, that he does not have a prior conviction. Is that correct?
Yes, Your Honor.
And then the court will note that he's been in the household for this length of time. Both parties have agreed that the witness has recanted. Here's my question for you, because I still, CPS does their investigation. Their investigation is their investigation. I know that you've been in the house for the length of time that you've been in the house. I know that you have cameras up. Question for the court is, will you make those cameras accessible to the DA?
Most definitely, Your Honor.
All right. So if he's going to make sure that the cameras are accessible to you, my understanding, it's an SD card in all of the cameras.
Yes.
All right. How often are you going to want to view the SD card?
Your Honor, I guess it's something I can work out with.
All right. If y'all discuss that, but I'm not going to order the no contact order based upon everything, the evidence that the court has heard based upon the indictment being incorrect. If the indictment were correct, this would be easy for the court to make a decision on.
May I ask my client one question?
Sure.
Off the record. Your Honor, it's my understanding that these SD cards record for 30 days. I would say.
Do they ever? Is there any recording over?
No, I was going to say, can we get a double and have them available for the state?
If you all will discuss that, okay. How often you want those available, but I'm not going to grant the request for the no contact order based upon the evidence that I'm hearing. But I am going to add the condition that the state is allowed to view the SD cards. And if y'all can just come back to me and y'all can write it in the order, how often you want those SD cards to be reviewed by you. All right. So will they be able to turn over the SD cards?
I will have my client buy additional SD cards and then provide them to me, and I will have them available for the state. And then I guess when we give them the next ones, they'll give us those back.
All right. So we're at the end of the month now. So I'm going to want an SD card provided to them before this month is out. And then after today, let me see. So that will, when will you be able to provide that to them? Friday?
Your Honor, I'm stepping into something I don't know. What I'm wondering is if I could provide like a 2 terabyte card and all these SD cards be loaded. That way the same cards can be used and I can constantly have these.
Sure. But my understanding though is, are you going to be able to provide it to them at the end of this month?
I'll take care of that.
Yes,
All right.
I will
So-
get more SD cards, and my outdoor cameras have a home base, so it has a 2 terabyte hard drive in it. If you have access to plugging it, I'll take the hard drive out and review it, and then I can put it back in.
All right. So we'll begin with the first date, the end of this week, and then 30 days thereafter.
Yes,
All right. Is there anything else?
not from the state judge.
Nothing from the French, Your Honor. Thank you
And
for
let me
your
see,
consideration.
does he already? Yes, he's coming back. All right. If there's nothing else, then you will be excused. And thank you for addressing the appropriate court. I'll sign this order and then you will have it.
Thank you, Judge, very much for your
You're welcome.
consideration.
Thank you. Court is calling 2025 CR 00867 State versus Samuel Joe Badillo Jr. Can I have parties announced?
Lauren, I forgot to put the state.
Melissa Christian for the defendant.
And are you Mr. Badillo?
Yes, sir.
Counsel, have you received all discovery?
I have.
Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Badillo, did you review the document,
Yes, sir.
the application for deferred adjudication?
Yes, sir.
Did you review it with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We did.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Are you proceeding with the
I'm
enhancement?
sorry. We moved to waive the enhancement and proceed as count 1 or 1.
Any objection?
No objections, Justice.
All right. Did you review the court admonishments with your attorney?
Yes, sir.
Did you understand it and sign it in all the appropriate places?
Yes, sir.
Did you understand your charge of possession of a controlled substance, penalty group 2, 1 to 4 grams? That's a 3rd-degree felony.
Yes, sir.
Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
We've discussed that, Judge. Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Badillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Oh, yeah.
Anyone promised you anything other than the plea? I'm sorry?
No, yeah.
Are you satisfied with the way you've been represented?
Yes, sir.
All right. So the district attorney's office has changed the paperwork. So I will not be asking you whether or not you're a citizen, but I'm going to give you these instructions or this knowledge and just internalize it, okay?
Yes, sir.
If you're not a citizen, you could possibly be deported, not allowed re-entry into the United States, and denied naturalization. Do you understand?
Yes, sir.
All right. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, there's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years, proof of employment that you obtain your GED, and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plea?
No contest.
State any evidence.
Yes, Your Honor, state offers has been marked as State's Exhibit 1 in all practical.
We have no objections.
All right, state, you may be excused. Thank you. Did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Just because they're.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, Mr. Badillo is very young. He's 22 years old. He's not employed at the moment, but he has independently been working on his GED. He got as far as 9th grade. He is not married. He does not have any children. He and I discussed the benefits of deferred adjudication, and we also discussed how important it is for him to immediately pounce on doing those 200 hours of community service and any classes or anything that the probation department might recommend. He is very interested in getting his GED and moving on with his life.
All right. So why have you not graduated high school? What happened?
I had dropped out.
Why?
I had family issues.
What type of family issues?
Got kicked out.
Why? I mean, there's a reason. I mean, if you have loving parents, you don't just come home one day and they kick you out.
I mean, it's just like the mother instead that, my mother chose her boyfriend over the son. So
All right. So, but why did she agree to kick you out?
she just did, I'm not, honestly, I don't know.
So do you have any siblings
Yes, ma'am.
and brothers, sisters?
Yes, ma'am.
Well, do you have brothers or sisters or both?
Well, 2 sisters, 1 brother.
All right. And how old are your sisters
17 and 12.
and your brother?
10.
All right. So do they have any problems with so just you?
My mother's no longer with my stepdad.
So who's your family support?
Yeah.
All right, just one moment. I'm sorry. Sorry, that's concerning another matter, another case that we've been waiting on. You're welcome. All right. So who's your support system?
My aunt.
All right. And will your aunt allow you to live with her?
Yes, ma'am.
And then the next thing is, what type of warrant did you have? Because I read in the police report that there was another warrant that was outstanding. What was that about?
Parole warrant.
Parole warrant? Is that from youth? When he was a juvenile?
Is that a TYC warrant?
Yes, ma'am.
Okay, it's an adult warrant from Bear County?
And you're saying a parole warrant?
I don't think that's right.
No, I don't either. I mean, did you go to prison?
Yes, ma'am.
Okay, what did you go to prison for?
Family violence.
All right, and was it prison or was it jail? How much time did you do in prison on that case?
Did a year. I'm like, they gave me a 4-year sentence.
Oh, they gave you a 4-year sentence and you did a year on it? All right. And are you still on parole?
Yes, ma'am.
And have you had a parole hearing yet?
They told me I wasn't gonna have a hearing until after this case was dealt with.
Okay, so counsel, do you want to go forward with this, knowing that he's on parole? Or do you want to discuss with him what potentially could happen?
We had discussed it previously, and this is now ringing a bell with me that we had discussed this previously. That was a situation, Judge, that case, he probably never should have taken a plea to prison in that case. And the parole board, the fact that the parole board was willing to wait to see what was going to happen here, indicated to me that this is probably the best course just to go forward with the deferred.
So do you know who the complainant is in that case? Because then I want you to make sure that you don't have contact with that complainant.
Who was the complainant, Mr. Bidley?
My uncle and my mother.
All right, your uncle and your mother. And the aunt that you're staying with, she's not married. You know, I know sometimes people will call their aunt's husband their uncle. So this uncle is not married to the aunt, is it?
No.
All righty. Complicated
Very
family.
complicated, unfortunately.
All right, so what were you doing using drugs?
I was having a little mental issues after,
What type of issues?
like depression, anxiety, and really that's really the only thing that I could think about going to was drugs.
All right, so this is what I can tell you. One, I'm going to try to give you conditions that can solve all these issues or at least put you on the right path. But I've done parole hearings in the past. Sometimes they wait to see what's happening on this case because then it makes it easier for them, right? And when I say easier for them, you enter a plea on this, whether it's deferred or not, they look at it as conviction, right? But I'm going to grant your application. We're going to try to get you some help. What I can tell you is people say probation in this court is not easy. I see people as human beings. Hopefully this probation will get you on the right track. And whether it gets you on the right track or not, 100% dependent upon you. But if for some reason your parole ends up being revoked, your attorney can come back and we'll see what we can do about this. Do you understand?
Yes, sir.
So knowing that parole could still revoke you, if you accept this plea, do you wish to go forward with the plea?
Yes, sir.
All right. All right, this is what the court is going to do. The court is going to sentence you to $1,000 fine. That will be probated. 3 years deferred adjudication. Proof of employment 40 days after release. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. There's going to be 200 hours of community service restitution. 100 of those hours will be deemed satisfied upon completion of a GED or some type of trade school certification. And since I know that you just went to prison for the family violence, the remaining 100 hours will be deemed satisfied once you complete an anger management course. There's going to be field visits 1 time per month until further notice. And I'm going to do a referral to felony drug court. That's going to be in custody. That will take care of, they have dual diagnosis. So if you have mental health issues, they'll be able to address that. Drug issues, they'll be able to address that. But you have to be honest with them. And what I can tell you, if you're in the felony drug court program, if you get accepted, that will be something that could help you with your parole. Okay, so that referral will be done in custody. They should be able to have us an answer back this week since it's Monday. Out of custody, we can do the TAP evaluation and mental and MIC. Probation, is there anything else?
Are you making anger management one of the conditions, Judge?
Yes.
Not the other.
All right, is there anything else you need from the court in order to be successful?
Yes, ma'am. And no, there's something else.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. You're young and you've been to prison. And I know there are certain things that happen in prison, and it's not a great place to be. But this is your chance to get your life on track. Please do not go out and start having children, because you're not ready to have children at this stage, because you have the parole matter, you have this. And so your life is a little bit in flux. You don't have a job, you don't have your education yet. So before you even think about having a child, get this under your belt, get parole under your belt. You understand?
Yes, Your Honor.
All right. In this court, communication is key. If there's an issue, don't just disappear. Let probation, you know you're having an issue. If they're not responding to you, you can come back to court. And counsel, if he ends up being revoked, you can come back to court with this matter.
Okay, Judge, thank you.
All right, thank you. Yes. Court is calling 2024 CR 010526-02. Can I have parties announced?
Carissa Chilkowski for Mr. Mishler.
And are you Mr. Mishler?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mishler, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears from the indictment and the plea paperwork you're proceeding on counts.
Just counts 1 and 10, Your Honor.
All right, thank you.
I apologize.
All right, if we can go off the record for a moment.
Your Honor, just for the record, my name is Andrea Crespo for the state.
I don't have the full indictment because this only has one count.
Yes, ma'am. I'll go ahead and bring that right now.
All right, so you're proceeding on counts 1 and 10.
Yes, Your Honor.
And how many counts?
There are 10 counts total, Your Honor.
All right.
And so we're proceeding on, 1 and.
All right, any objection to the waiver of the other counts?
No, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, did you understand in counts 1 and counts 10, you're charged with possession of child pornography younger than 10 years of age and possession of child pornography less than 50 videos. And the range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine, and anywhere from 15 years to 99 years or life imprisonment with a possible fine up to $10,000. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
We have, Your Honor.
The indictment being finished right now, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
We do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was.
And counsel, you want to announce as well?
Sam Locke, with Ms. Chilkowski representing Troy Mishler.
Mr. Mishler, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
I'm so sorry.
So this is State's Exhibit 2, Your Honor, with the motion to seal attached. So that was just defense's copy. So this
All right.
is-
Thank you. All right, we can. Let me re-ask that question because the paperwork has been changed. Do you understand that if you were not a citizen, that based upon these charges and entering into a plea of any of these charges, you could be deported, not allowed re-entry into the United States, and denied naturalization? Did you understand?
Yes, ma'am.
All right. All right, everyone, if y'all could stop approaching, we're on the record, and I'm trying to focus on this. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on counts 1 and 10. They're asking that your punishment be assessed at a cap of 30 years in the prison. There's a $5,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes,
Counsel, are there any such motions? To count 1 in the indictment, how do you plea?
guilty.
To count 10 in the indictment, how do you plea?
Guilty.
State any evidence.
Yes, Your Honor, the state moves to admit states exhibits 1 and 2 into evidence.
We've reviewed and have no objections, Your Honor.
All right, and with regards to the seal,
States exhibit 2, Your Honor, it does have a motion and an order to seal on that record regarding the content of.
all right, any objection to the court signing the motion to seal?
No, Your Honor.
All right, the court will find the motion to seal, which is a part of States Exhibits 1, and it's listed as States Exhibit number 2. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. What are we here for? Is this for a motion?
This is a motion to revoke probation, Your Honor. My client does intend to plead true.
All right, could I have the motion to revoke probation on this case, please? All right, court is calling 2024 CR 012861, State versus John Berry. Can I have parties announced?
Lauren Espinoza for the state.
Renee Munoz on behalf of Mr. John Berry.
And are you Mr. Berry?
Yes, ma'am.
All right, did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same John Cowan Berry Jr. who was placed on community supervision in 2024 CR 012861 for the offense of evading arrest detention with a previous conviction on February 27, 2025 for a term of 4 years?
Yes.
All right, state.
Yes, Your Honor, state is proceeding on violated condition number 41, which states on or about the 29th day of July, 2025, in Bexar County, Texas, the defendant, John Cohen Berry Jr., did then and there fail to comply with the rules and regulations of the felony drug court in violation of condition 41.
How do you plead to that? True or not true? And state, are you waiving the other allegations?
No objection from the defense.
All right, did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, ma'am.
Court will find violation of condition number 41 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke sentence to 2 years, as well as take into consideration clause number 2025 PF 29310.
Your Honor, we would just ask if we can just be heard in terms of the time of confinement with certain justifications related to substance use disorder.
All right, and the case that you're asking to be taken in consideration, what were the last 4 digits again?
29310.
And what is that offense?
That is possession of controlled substance 51.
All right. So are you in agreement with revocation?
Yes, Your Honor.
Okay. And then the court then will hear your argument with regards to sentencing.
Thank you, Your Honor. Concerns of the punishment to be assessed by the court. We asked the court to take judicial notice on the court summary provided by probation that he did successfully complete lifetime recovery inpatient for the dates of March 14th, 2025 through June 30th, 2025, which he was issued a certificate of completion for that inpatient lifetime recovery. We do know, and we are aware that the court knows that he was subject to felony drug court conditions. He did suffer a relapse in which he self-admitted to felony drug court that he was using substances. So there's no dishonesty behind his issues, Judge. He did kind of fall off. He was at a sober living home, and then he did abscond from there upon relapsing. He did state reasons for doing so, where he was trying to get back to his family members that live in New Mexico. He did state that his grandmother is suffering from